All right. My name is Tariq Hafiz. So you heard that correctly. There are two Tariqs here, and we're not the same person. I am a co-founder of LegalEase Solutions. I grew up here in the Metro Detroit area and practiced law here in Detroit for a while before starting LegalEase Solutions with the other Tariq. And the secret of our union is you got to have a name like Tariq to join the company. But very happy to have you all here. Thank you so much for coming on this Thursday frigid morning. I think our first panel was amazing, and I'm sure we're all gonna do just as well. This is amazing this morning. So we heard a lot about all the great things that AI can do, the advancements of AI, the potential of really replacing a lot of that high volume, repetitive, what we sometimes call commodity legal work. AI definitely has a lot of potential there to do that. It's already doing it. But we also, as lawyers and as professionals who are in the legal ecosystem, we also have a responsibility of using AI and technology responsibly, right? And making sure that we're not compromising on our clients' data. We're not compromising on the accuracy of our work. We're not compromising on our ethical obligations as legal professionals. So data privacy, data security, ethical responsibility as legal professionals, these are all things that we have to continue to think about and address as we start using more of AI and automation. So I think Tariq Akbar had the job of sort of having a fun conversation around, hey, AI is so cool, look at this shiny new tool, look at all the great things it can do. We're going to bring it down a little bit and talk a bit more about, hey, we got to be responsible in how we use it, and what are some of the things that we can do to prevent the misuse of AI or to better regulate it. So I'm joined on this panelist today with James Reed, who's a partner at Honigman. Honigman, of course, is a sponsor of this event. And James is focused on labor employment law, but sure does a lot of other things as well. And we also have Marla Zwas, who's Chief Legal Officer at Cabinet Works. Marla's had an extensive career in-house, and I believe she worked at Chrysler at some point as well.
James, we did not overlap. You came about a year after I left.
Okay, awesome. And James and Marla are both local, and then we're also joined by Jonathan. Jonathan Greenblatt is from Boston, and he is with LinkSquares. He's a VP of legal at LinkSquares. LinkSquares is a legal tech company, and maybe you guys can just say hi and say a few words about yourselves before we jump into the discussion.
Sure. So I'm James Reed the fourth. So to continue the Tariq conversation, James Reed the fifth is my son at home. So the pressure's off. And our law firm has about 400 attorneys. We cover about 60 practice areas. And there are three main focuses of employment law that I specialize in. And one is kind of the front end, advice of counseling, policy, innovative, kind of talk therapy counselor to how to handle employment situations. Phase two is more of the litigation in court. And then phase three is mergers and acquisitions and how to consolidate AI and cultures and harmonize companies as part of that growth process.
Hi, good morning. I'm Marla Zwas. There are no other Marlas, as far as I know here. Anyway, I work for a company called Cabinet Works Group. We are 8,000 to 9,000 people, headquartered in Livonia, Michigan, making kitchen cabinets for 550,000 kitchens a year. So it's a huge company. I have worked in a number of in-house roles. I did work in private practice for almost a decade. And I have been at companies like Chrysler and Pulte, which are public, privately held companies like the company that I work for now, so private equity owned. So it's been, my career sort of been all over the map with big, small, private, public, in-house and outside, so quite the variety bag.
And my name's Jonathan Greenblatt. Tariq mentioned that November's a beautiful time to come to Detroit, so I decided to make the trip up here. And it's been great. So yeah, LinkSquares, we have an AI-powered contract management product along with another product that allows you to manage the rest of your legal work because we do more than just contracts. And in my role, I'm a generalist, so I do negotiate the contracts, but I also do the corporate work, deal with the IP, etc. I've worked a previous 10-year experience working in-house at various SaaS companies in the Washington, D.C. area.
Well, thank you everybody for being here. So like many of you, I first learned about ChatGPT not from Cranes or from the Wall Street Journal. My college-age daughter told me about ChatGPT about a year ago. She said, "Dad, I've heard about this ChatGPT thing," and I was kind of embarrassed because I thought I knew a little bit about technology and what's going on in the world from a legal tech standpoint, but I'd never heard of ChatGPT. And my daughter, who at the time was a junior at U of M, she's like, "Yeah, all my classmates are using it for writing papers and helping us, or really doing the work for us in a variety of ways." I'm assuming a lot of you guys probably heard about ChatGPT through younger folks as well, because it really blew up on college campuses and high schools, which leads to kind of my first question to James. ChatGPT is great, AI is great, but how do we make sure that we're using it responsibly, especially in the legal space? Since, we're lawyers and we have ethical responsibilities to our clients.
Yeah, it's a great question that is constantly evolving. So as we heard from the earlier panel, you don't want to block AI or ChatGPT from a tool for lawyers, but how do you draft a policy where the technology is way ahead of the laws, way ahead of regulations, way ahead of what most HR and in-house attorneys have even fathomed of how to get your hands around it. And so from my experience, the hottest issues I've seen, even though AI has been around 30 years, the hottest, and AI is defined more broadly as technology that helps you make decisions. So it's not just ChatGPT, but essentially we have to worry about the negatives of AI too. And the negatives are people are plagiarizing. Someone is saying, "Hey, give me this cabinet design, put it in," and they turn it in as their own product. And now we have some issues with IP violations and also our employees not doing the work we expect. We have many challenges with confidential information being disclosed. "Hey, I make this amount of money here. I have this idea and formula where I need to solve this problem." Now all of your confidential information is out there and can get sold on the dark web and is not protected or regulated. And then 3, AI is not just Michigan-based or American-based, it's worldwide. So some of the AI coming from China, where it's legal to discriminate based on age. There's just a case in America where iTutor Group, the applicant tracking system said, "Let's screen all these people 55 plus for the most part," and that's blatantly illegal. And even beyond that, plaintiff attorneys that represent just the individual employees against major companies are salivating with the use of AI because there's new case law where even if there's no intentional discrimination or bias, if there's a more than 20% variation of statistics of who you're hiring based on a protected class, such as race, age, Michigan protects height, weight, marital status, family status. If there's any statistical difference, that in and of itself is enough for a plaintiff attorney to bring a discrimination claim that could then take a case all the way to a jury trial.
Do you want to comment on that at all, or sort of the risks associated with using AI?
Right. I would add about the sense of responsibility. A great example. Garbage in, garbage out. It's no different than what just a data system that you might be using every day. I'll give you. Let me give you an example. We had a fight with our trade association. Us and the 2 other biggest cabinet companies, and we quit the trade association. Trade association, one of the things that they did that was valuable to all of us was they aggregated the data, the sales and revenue data for all of the industry. And everybody relied on that report heavily. And when we all quit, the 3 biggest companies, our data was no longer included in that analysis. People still are relying on that data, even though probably a third of the cabinets sold in the United States are not even calculated in that data, and the types of sales that we do are completely different than than the smaller companies. If you actually probably asked ChatGPT today how many cabinets are sold in America, you're going to get a garbage statistic. So you're going to get something that's completely inaccurate that people might base a decision upon. So one of the things that concerns me is sort of that garbage in, garbage out. Should I go run to ChatGPT now and tell them my annual sales so that we're sure that this is similar to the inherent bias, but this is on the business side. Should I go and tell ChatGPT how many cabinets I'm selling so that when people pull that data, it's more accurate? So it concerns me that the data set is sometimes unrealistic or unfair or inaccurate, and that we would be relying on that to make important business decisions. That's one of my very short-term concerns.
I'd actually like to just jump in and talk just on the overall risks. There's a huge human element that's a risk. I'm sure, Tarek, when you found out that your kids were using ChatGPT rather than thinking through it themselves, you were really concerned less about like the plagiarism and more about are they learning the skills that they need. And I was actually just chatting last week with a professor from Princeton, and he actually thinks one of the biggest concerns is the next generation will not get the same training. And essentially what you're going to potentially have is like a huge level of knowledge workers from a previous generation, so go Gen X, that's going to be able to essentially effectively use these tools with their training, and you're leaving out a whole nother generation.
Absolutely. I was proud of her for learning about ChatGPT, but then when I realized what it does, I was a little bit worried, and I'm sure we all are. Marla, in your role as sort of chief legal officer, you know that your employees, whether they're in the legal department or elsewhere, engineering, design, they have access to AI and tools that are publicly available. They can subscribe to their own, tools out there. How do you think about that, in your role in terms of, how do you regulate the use or misuse of AI, first at the workplace, but then what stops somebody from going home and turning on their laptop and doing something, even if you have regulations or policies against it? So how are you thinking about those issues? And I know these are all, in many cases, new issues, so you may not have the answer, but I'd love to sort of hear about how you're thinking about that.
Right, well, we're just like any other manufacturing company, probably very nascent in our development of policies around AI. We are just starting to think about this. I mean, last week, the biggest concern, and I'm saying last week sort of theoretically, but is trying to get people to stop phishing, accepting phishing emails so that we don't wire millions of dollars out of the company to bad actors, which, is a constant threat to our organization and organizations like us. And so we've been training to death on that little sort of strip of issues related to phishing. So we know that it's the human fallibility that is going to make it difficult for us, and we definitely have to develop policies around this. Right now, the running rule at a large company like mine especially, but any really tightly run small company too, would be you need to use the tools we give you. Please don't go find your own tools. I mean, we don't want you to use Gmail to conduct company business. We want you to use the tools we give you and not run off and try to find your own independent tools. If you think there's a tool that's great, let's discuss it, let's share it, let's figure out if it makes sense to the organization. But our job, policy-wise, is probably going to be focused on sticking with the tools that are given to you and training people to understand how important it is from a security perspective. We just recently hired a CISO, a Chief Information Security Officer. I'm well familiar with that because I did do a little delve at one point into the banking industry, so very familiar with CISOs because they've been around a long time in banking. But that person is hopefully going to lead the charge for us to develop policies around this. But let's face it, there's no policy that makes any difference. If a policy falls in the forest and nobody hears it, it means nothing. So those policies are going to have to be coupled with constant reminders and training.
Jonathan, sorry.
Oh, well, actually, I was going to ask a question because this is a huge challenge that we're having right now. How are you guys communicating that to your employees? Because folks are jumping on all sorts of, and they are cool tools, and they're usually free, and they come with the crappiest terms. How do you sort of control that? What steps are you guys taking?
This goes back to all the things that, the click wrap authorizations. I mean, we're back to that phase again of reminding people that they cannot accept terms on behalf of the company. And so every quarter we send out a reminder about, can you sign anything? I call it the don't even give anyone your autograph rule. You can't sign anything for the company, and that includes checking an I accept box. And so, it goes to that. So if you're clicking, so what I try to do with these quarterly reminders is, vary them a little bit. So now those quarterly reminders incorporate messages about accepting, using ChatGPT and things like that. I mean, but like I said, very nascent. We're just starting those communications. Those are just those are just emerging into policies. I'm sure that we're going to have some damage before we get in front of it. There's no question, but especially with compromised confidential information. But we're going to try to get there.
James, do you want to say something?
Yeah, so there's several things you can do to be preventative or at least minimize risks. So the first thing that Honigman does for our employees is we have a certain server. We can't cut and paste emails to our private, whatever internet browser we use. And we have various cyber training every month that we have to complete this training in order to stay in good standing at the firm and earn rewards points to buy some swag. And then 3, we actually have policies in place that essentially require us to not rely on artificial intelligence. Similarly, you can't blame it on a secretary, you can't blame it on a paralegal, the lawyer's responsible. So treat AI as almost a resource to maybe give you some efficiency, but you can't rely on that. And then there are documents you can prepare in your policy that is not common sense. So for example, the Defend Trade Secrets Act is a federal law. And if you have certain language that says employees are allowed to whistleblow illegal activity that they find out in the company, in exchange for that, they'll agree to keep all of our information confidential and not put this information out on, ChatGPT or elsewhere. That would allow the company to get treble damages plus attorney fees plus a federal remedy to actually allow a court martial to go retrieve that computer back and that property back. And there's also ways to get insurance. So you can buy cyber insurance and make sure you're aware of all the carve-outs and technicalities to comply, because most of the cyber insurance says there's annual training done. And based on AI search, only 15% of companies do any type of training based on AI. So if you do that training, then all of your insurance coverage could be invalid based on not following your warranties and representations. And then third, you could outsource some of your enforcement procedures to a third party that may help you with AI tools, and you could have indemnity agreements negotiated with those third parties to maybe have some of the responsibilities shared.
Speaking about enforcement as an employment labor lawyer, what are some things that companies can do to enforce these policies, other than kind of some of what you mentioned, sort of more along the lines of, is that grounds for termination or discipline if they're violating these rules and policies around using technology outside of the workspace or accessing websites or technology tools that are not sanctioned by the company?
Yeah, the standard policy violation is disciplinary action up to and including discharge. So that's the problem with policies, is your only enforcement tool is a write-up or discharge or some level of discipline. Maybe give them more training, more unpaid time off, more, less favorable shifts or work until they get back on schedule. If you really want to have a better remedy or protection, you have to have an employment agreement signed or a vendor agreement signed to get contractual protections that would also give you more leverage than just the ability to discipline.
Jonathan, next question for you. What are some of the privacy concerns that legal departments or law firms should be concerned about when talking about using AI tools?
Yeah, so I mean, there's the ones that probably are going to come first to mind: confidentiality and having your data potentially exposed to a training model that's going to then, tell somebody else. Like, this is one of the big things with generative AI is now, like, the AI can talk. Before, it couldn't really talk. And now, so there's a risk of your data now getting potentially exposed in any model that's used for training. So I think one of the things as legal departments, we always need to be asking with these AI tools is, like, are you using our products for training? Or is it what our data engineering teams calls it predictive? Like, are you using it to essentially just provide us like the use of the generative AI tool without that data getting put into the model? So I think sort of confidentiality is the first one, but also I think we always think about external confidentiality, but like, what about internal confidentiality, right? Like, I don't want, if we're doing like an M&A activity, I don't want my sales team going into the Gen AI tool, putting in something and all of a sudden like getting the M&A agreement. So what permissioning, like how is the AI, like particularly when we're talking about AI tools, like how is it getting permissioned such that you're not actually releasing information internally that you wouldn't want folks to see? And so, I mean, a lot of this just goes back to general, like your general company policies, but it's getting harder and harder because of the proliferation of a lot of these tools, particularly like, you know, we were talking about the, like superpower.me. I'm not sure if anybody has seen that tool, but essentially it allows you to record your conversations and it gives you a summary. It's actually a very good tool and it's free, but like, I don't want employees recording other employees. I mean, that's the use case, but it's the Gen AI is making it very effective for particularly like neurodiverse employees who can't concentrate a whole meeting to be able to get a summary, and they value that. And so essentially, like, you know, as a legal department, like how do we talk to our IT team and say, what are the tools that folks can use that we're comfortable with? I'm actually very excited about Microsoft released Copilot for Enterprise this month. And that's gonna be a big change because I think folks are very comfortable with Microsoft. I am personally. And so I think having folks stay within that ecosystem is going to make me feel a little better.
I do worry about confidentiality quite a lot, and I just worry about people going off the reservation and doing their own thing. That is really, it's very hard to protect against that that activity, that you know, that sort of human activity. I want to try this out. Let me see what happens if I do that. I'm more concerned about that, like the system implementation, like what we actually use, what we intentionally use within the organization, I think is less of a concern. I'm more concerned about sort of the loose experimenting and, you know, like let's see what this program can do, and that, you know, that's exciting for people, and I get that. I saw a fantastic demonstration just recently of using ChatGPT to take certain financial information and distilling it into one of those fancy decks that you see presented by, you know, by investment bankers. And in the reverse, I watched a demonstration, you know, same demonstration, taking that deck and turning that into a management discussion and analysis of the kind that you would plug into an SEC filing. I mean, it is overwhelming how much can be done with these systems and how tempting it is going to be. I mean, you know, as we discussed our own, you know, my own kids too, it's super tempting to try, you know, hey, I don't have enough time. Let me see if I can get this talk that I'm giving to be ChatGPT. It's gonna be, we're gonna be fighting personal temptation is really what the war is going to be, just like with the phishing.
And my biggest concern from an employee issue perspective is that 90% plus of employees are not in the C-suite. So when they're getting this information, they're figuring out how to make more money for themselves and how to say, you know, and then they have skeletons in the closet, they believe, on their company. They think they have, and so they essentially find the good, bad, and ugly, and then feel that leverage can be utilized for personal gain. And so I think it's very important to work with your IT department and third parties to make sure information is only shared on a need-to-know basis, because employees are more entitled today than they've ever been in the last 100 years from the studies I've seen.
Can I add one thing? So in addition to confidentiality, I think the automated decision-making, as James pointed out, like that can potentially become a real risk, that we're going to now have to analyze how our HR departments procure their software that's going to make automated decision making, because if now we're going to be subject to a plaintiff's lawsuit anytime we use XYZ product, it's something that we're going to now have to at least show that we've done diligence around making sure that we're choosing non-biased products.
Another interesting risk too, to me, building on something James said, is disinformation. One of the interesting things that happens to me about 470 times a day in the C-suite is that somebody brings something to me and said, I heard a rumor that, or I understand that, when you go off site, your lunch gets bought for you every day. When some disinformation campaign about salaries or bonuses, things like that. I must say, I like every single day, there's never a time that I say, that's not true, or where'd you hear that from, or where'd you get that from, or why do you think that? Because there's just constant disinformation, which then in turn affects the morale of the organization. It does concern me too that disinformation coming from these sources will inform people, and they will then emotionally react. They will feel a certain way, which will affect their performance and their longevity with my company. I think it's so important to realize all these emotional and human factors, sort of the effect of disinformation, as well as the temptation of using these products.
Absolutely. So Jonathan, you are VP Legal at LinkSquares, which is a legal tech vendor. What are some things that legal tech companies are doing, like LinkSquares, to protect data? If a client signs up for your CLM software, how do you reassure them that their data is safe with your tool?
We've been actually very cautious with generative AI. There's applications, but we're being very thoughtful about how we do it. But I think a lot of this goes down to basic security, and also really understanding essentially the models and sort of where the data will go and what the potential output will be. I think all of us legal tech vendors that are like beyond a sort of a Series A round, like we're very thoughtful, because we do not want to be the vendor that the horror story comes out about us giving some sort of confidential information. Particularly, we have our newest product is allowing legal teams to manage all of their work in our product, and we cannot have such sensitive things like litigation potentially going to another side. I mean, I could only imagine, like, we have both sides using our product, and one of them gets really confidential information from the other side. So we're being very thoughtful and being like, you have to be 100% sure data will not cross-contaminate, and you have to be thoughtful about when it makes sense to sort of train. Like we do train on contracts, but we're very thoughtful about how we do to make sure that it's always sort of de-identified. But when we go to the Gen AI world, we're probably not going to train on those contracts. We're just going to make sure we're going to use the LLM of choice. That will be fine-tuned, but we're probably not going to train on the contracts, because there's just too much of a risk of that data getting out.
Are you seeing a lot of negotiation around MSAs or service orders around these tools, maybe more so than you would otherwise because of the sensitivities around data privacy and data protection?
Yeah, we're getting better questions, particularly like we are an AI-powered tool, and I think we're honestly, like, the legal departments understand us. And so we're one of the, like, they really get it, so we would get all the questions now about specifically how our AI works. And I think those questions are going to be just repeated over with other tools where it's probably like a more sensitive use case in the sense of like how we're using AI. But I think we've actually tasked our engineering and marketing team to come up with a one-pager that we can hand to customers, because folks are going to become better informed. This to me is like GDPR, where it really forced folks to really understand where their data is going. And I think like over the next couple of years, people are going to need to understand what the AI is doing.
I'm really focused on drafting data retention policies for many companies. At Honigman, all of our emails are deleted every 90 days, if not saved to our server, because nobody wants to go back 20 years and have to produce all emails with a certain buzzword in it. So I think you have to be more cognizant of what your policies are at your company. And also, we implement screens. So if there is a big company going public or a big merger, we can't have that getting out. That loss of trust would hurt our brand tremendously, more so than any type of damages lost for that particular transaction. So most contracts with third parties carve out indirect damages. So it's extremely important that you're aware of how you could get around minimizing that exposure to your brand and how to protect that data by being preventative and having somebody at your company that monitors it to make sure it's followed and enforced.
Cool. So James, since you have the mic, I'm going to ask this next question to you. Give us some sort of high-level ideas on if you're an in-house seat or you're in a company that's looking to draft some regulations and policies around using generative AI tools or the tools of the sort that we're talking about today. What are some things that you would want to make sure you'd have in those policies and procedures?
So I actually typed it in ChatGPT and said, send me an AI policy. And honestly, it was about 80% helpful in getting the initial template set up. But I think that it's very important to tailor. We don't sell widgets. You got to tailor that product to your culture and your company. And maybe the title of the person is completely, they don't have that at your company. Most companies that are under 500 employees don't have an in-house counsel. So they have to, either outsource that or there's somebody that has a different title that's trying to play lawyer and figure it out. So I think at a minimum, you would want to define confidential information very well. You would want to identify a disaster plan. If there is an issue, they make a mistake, who do they report it to and how quickly? And there are new laws that you have to do disclosures if someone's W-2 information got out within 4 days or less. So be clear on how to immediately report and the timing to report. And then I think 3, make sure there's a training beyond the policy, because it used to be, everyone would get a handbook that had every policy under the sun buried in it. But now we expect to have a video we watch that summarizes it all for us. And if you don't have that technology and that live training, nothing's going to stick, and there'll still be a lot of violations with that policy.
In the policy and in the training, it's really critical to get viewers and readers to make that mental connection between their own activity and what the policy is talking about. I know that sounds really dumb. Like, we're all lawyers or in the legal field and read policies, and we instantly start analyzing how that maps to us or to situation around us. But a lot of people, when they're doing the uptake, they're not really connecting how this is related to their activity. And I think that when you do it, it's certainly about tailoring it to your culture. But when you're reviewing multiple training resources, I can't emphasize enough that not every training resource is the same. And when you pull them up and you're just like, oh, check the box, I've got to have an AI training now. It is critical that you review those trainings and you really look at whether that training is structured in a way that helps people connect this with their own personal activity. I can't tell you how many people say to me, like, oh, I read the bribery and corruption policy, that doesn't affect me, but then I'm buying dinner for this person. Like, well, have you thought about, and people just don't draw those analyses together. We all tend to do that because that's the way that we're trained to think, and it's the way maybe we naturally think, and that's why we went into this field. But a lot of people don't think that way. So it's critical to get this really good training that's very plain language and that helps people, that's very specific driven, example driven, and examples that really are things that could happen in reality. So it's critical to get the right training.
Yeah, I would just add with policies, one thing that we're finding to be somewhat helpful and is bright line rules, like figuring out what are the use cases that you absolutely don't want folks using Gen AI for. That's code. Like, we don't want our engineers using Gen AI for code right now. And so there's like multiple reasons, right? There's the confidentiality piece, but there's also like, we don't know how investors are gonna view code written by AI. And at minimum, we're gonna wanna watermark that and make sure that we can essentially distinguish that. So we've made a couple bright line rules, and I think one of the struggles is like, you're not gonna evaluate every product because a lot of these products have already been bought and now they're turning on AI. Like, my CLE had like a Gen AI assistant in it. So I think at some point you also have to use, like, just tell folks to use good business judgment. But I think bright line rules where you absolutely don't want folks using Gen AI is pretty helpful.
And another feature is that AI can be used to track enforcement and compliance with the policies. So you can monitor each time an employee types in ChatGPT and what they type in the search, and the AI could, red flag certain people in IT of any abuse, and you can monitor keystrokes and how long they're in various documents and resources. So I think AI could also be a good monitoring tool.
Cool. I've got one last question for the entire panel, then we'll open it up for Q&A. Given what we've heard about in terms of the potential risks associated with using AI tools like ChatGPT or very specific LLMs that are for your organization, each of you individually or personally, are you a fan of it? Do you think it's something that's going to continue to be used within your own workspace? And if there was one tool that could really make your day a lot better, whether it's existing or not, what would that tool look like?
So am I a fan of it? Absolutely, yes. I think I was always against companies that blocked employees from going on Facebook or Instant Messenger or doing any type of technology-based work during the day, because we're all about efficiency and getting answers from our colleagues and our friends and our resources. When they blocked Facebook, I would just turn off the Wi-Fi and go text on my cell phone or use it on a data plan back in the day. And so I think companies need to encourage employees to take advantage of technology as a matter of course. And as far as my favorite feature of AI, I use it more as a blind spotting mechanism. Like, what am I missing? And I love the idea of making sure that I'm not missing any concepts or big red flags as a guide.
If I could have the perfect system, it would just function as my own memory, remind me of everything that I was supposed to do that day and not let me let anything slip. That would be my dream. And the other piece would be to take away some of the more mundane types of jobs that are the least satisfying jobs in our department, and allow people to, like we were talking about in the other panel, to graduate to more sophisticated technology management jobs. And that's happening. I just would love to blink my eyes and it already happened, but yeah, that would be my dream.
Like reviewing NDAs?
Yeah. Well, reviewing, I actually was thinking particularly in, we have repetitive paperwork, like we bring in international shipments, and so we have a lot of customs paperwork. Everybody does customs paperwork slightly differently, so it has to have the human review. It can't currently, you can't just it doesn't feed into a database. So I really look forward to the day that we can use a program, I mean, we're already looking at it, to scan these documents, to pull out the correct fields from documents that all look a little different. It's a very unsatisfying job. Nobody wants to be doing this audit work, and that's an example of something that I look forward to leaving behind and having my next gen employees who are on my succession plan, because we all have succession plans now, so we want to develop those folks to be sort of technology driven, talented people versus people that were really good at just running through paperwork very quickly.
Yeah, I actually really like it to proofread my emails, particularly when it's late at night and I'm trying to send out an email, my eyes are blurry. It does a great job of capturing like the 3 ofs that you've written in a row, or that sentence that you rewrote, and all of a sudden it kind of is a little bit off. So it's a great proofreader.
And I was just going to add, as far as like future trends and predictions, I'm pretty active in the HR world called Society of Human Resource Management. And one of the main benefits of AI is it can predict burnout and mental health challenges and help you know when to check in with your employees. And the other prediction is that by 2035, half of the workforce will be gig workers. So AI will be able to take up the main, more repetitive work and you'll have more consultants and gig workers that come in with a special skill set more fractionally, and they can do the more rewarding work probably at triple the pay, because they're not spending 75% of their time doing basic work and only using their skill set 25% of the time. Now they can use that skill set 100% of the time and still be cheaper overall for the businesses.
Awesome. Thank you so much. All right. Any questions in the audience for this panel?
Thanks. So I appreciate everyone's thoughts on the guardrails that we have, within our specific practices and what we're doing, but we might do a bit of a thought experiment here to kind of get everyone in the room to start thinking about what might be some of the more creative ways that we have to either push these guardrails out or really bring them in tighter. So many of you have client data, right? Especially in the law firm space, and you're hosting that within specific software providers, or you might be hosting that in-house. I'm a startup that comes to you and says, I want your data. You have tokens that I need to feed into my models so that I can train them to predict what's going to happen for my future clients, and they'll be able to use the learning that comes from these tokens. So now, I'm sure law firms have the T's and C's in place where client data will be protected, will be safe, and whatnot. And I'm going to combine both the law firm space and the software space here, right? When I say that, fine, maybe we can't share out this data in this way as a token. But I'm using software, and I'm creating queries, and I'm creating my own work product as a lawyer inside of my case management systems, or inside my e-discovery systems, or whatever those systems might be. And that's not client data, that's my own work product. Even though I'm applying it to the data that's being stored, that's client data. Can that be shared? Can that work product that I'm creating, and we're not talking about contracts here, we're actually talking about queries, right? The queries that I'm gonna put into a review software or into a case management software is my own. Can I, as a law firm, share that out? And subsequent to that, can the software company take the queries that are being generated in the software that they're hosting for these clients and say, that's different than the client data that law firm is hosting inside of my platform? And so the question really becomes, have we pushed the guardrails too far when we've protected our own data, when really we were trying to protect client data? Or do we need to tighten this up and say that even the work product that's created as a result of this data that a startup like me can come and ask for as a token, does that have to be protected as well?
So at Honigman, we try to be the front end of all queries and concepts and innovative in the area of law. So we often participate with ICL, which is the Institute of Continuing Legal Education, and give them all of our concepts and trends and toolkits and databases. In our team, we have 15 attorneys in our employment group that meet every Tuesday at lunch, and we share all of our databases and tweaks. Now release agreements require an SEC, carve out and disclosure. And so we meet every week and continue to do that. And we always share it with other attorneys, other law firms, other clients, because we consider those templates that will allow everyone to know that we're on the cutting edge of law, and hopefully they'll hire us to tailor and tweak their product. So I don't see any policy that would prohibit us from sharing the client scrub data.
And I would just say, I guess on the queries, I think the Google has been getting legal queries for 20 years now and doing their own research and analysis on that. So I think it's going to be the fundamental rule is it going to disclose, or essentially, are you in any way going to disclose client confidentiality or attorney work product? And if the answer is yes, then you absolutely can't do that. But is there potential for folks to do research on some of those queries? Yes, I think so.
I'd say the carve out to that is we also have intel on judges and attorneys that we interact with, and we don't want to disparage them, out in the public record. So that would be more of a private database kind of queries that we do internally as well. But for the most part, if it's product that could be given to opposing counsel, then it's no longer confidential anymore. So we consider those concepts free to share.
I would agree on the template thing. I'm a lover of the templates, and actually from job to job, there's times when a law firm and I have worked together to develop a template, and then I go to my next job and I go, I'm going to mail you a check for $1,500. Can you give me that template again? Because I'm at a new company, and I won't port it over without paying the law firm again. So but I do love templates, and the more sharing we do, I think the better our profession becomes. But you know, it does concern me. For instance, there's many times when we're in litigation and we're trying to come up with an innovative theory, you know, or an innovative strategy to attack something. And speaking as a client, that's something that I would viciously protect, much like the judge and lawyer intel. I'm really excited now to go over to Honigman and find out what does it say about Marla Swass. Sure, it's a real choice, but I think that you know, it's important to me, like from that strategy, you know, the attorney work product doctrine. I mean, we want to make sure that we do not erode the doctrine in the name of, you know, templates, which are great, but there's also like a stopping point with innovative and creative thinking and strategy that I'd want to be sure that I'm keeping close and that safe. So
I just wanted to throw a little follow-up in there. So there's a third party in the room, right? There's the firm and there's the client data, but there's also the vendor that's hosting your data for you, okay? And they're also the ones that are tracking literally every query that you put into their software. Can they use it as a token for their learning models?
I mean, they could take those statistics, you know, they can look at things, aggregated statistics and things like that, but the qualitative nature of the inquiry needs to be protected. You know, they cannot share that. I'm sure that, you know, as we're doing these agreements, we're looking at what's protected and what's not protected. We're looking at, you know, you can have aggregated, anonymized data, you know, on statistics, but you can't anonymize my qualitative inquiries. It's impossible.
Right. That's a provision that's always negotiated in the contract.
And I would say, as we are in the midst of literally thinking about these specific issues for our product, which will be case management, like these are some of the things that we're thinking about. And I think ultimately at the end of the day, you have to sort of make sure, like, use good business judgment. And, you know, if this gets publicly disclosed that this is how you operate, is it going to pass a smell test? So it's definitely, it's not, there's not a super easy answer, because there's a line, there's essentially a line between like qualitative and quantitative as to sort of how you approach those issues.
Any last question before we wrap up?
And while we're waiting for any last questions, I want to thank Waldron for getting us this space again today, and hosting breakfast as well. Thank you, Waldron. And thank you, LegalEase and Honigman, for co-sponsoring this event.
Yeah, and feel free to stick around for the next 15-20 minutes, grab some more coffee or whatnot. Some of the panelists might be able to stick around a little bit longer if you want to ask them any questions. But I really want to thank you all for coming this Thursday morning. Appreciate your attendance. Feel free to grab those notebooks on the tables. Feel free to grab any literature about Honigman or LegalEase or Waldron. But we'd love to continue engaging with you and speaking to you and sharing ideas with you guys. So thank you again to all the panelists. Round of applause for the panel here. And thank you everyone for coming. Have a great rest of your day.